Good afternoon. I just want to welcome you to our third annual Rosenkranz debate. I want to express our gratitude to the Rosenkranz Foundation for supporting this event, and to Nick Rosenkranz also for suggesting this as the perfect Saturday centerpiece for our convention. It's really worked well. An intellectually sharp, one-on-one debate between two highly prominent legal theorists. This series had a wonderful start in 2008 with a discussion between judges Richard Posner and Mike McConnell, former Judge Mike McConnell at this stage. And last year, the debate featured judges Guido Calabresi and Frank Easterbrook. Frank's here today. To moderate this year's debate, we're delighted to have Judge Robert Smith of the New York State Court of Appeals, the highest court in New York. Judge Smith. Judge Smith has quickly acquired a reputation as an outstanding intellect on that court. Previously, he had a very distinguished career at Paul Weiss, and we owe him a debt of gratitude for his prior service to the Federalist Society as president of the New York City Lawyers Chapter. Judge Smith?
Thank you. I'm going to take very little of your time because I don't really think there are many people here who do not know who Professor Richard Epstein and Professor William Eskridge are. I gather there are biographies available to you, which would take quite a while to go through in detail, but I think it's probably enough to say that they are generally recognized as two of the outstanding legal academics in the legal academic business. The format of today's program will be that Professor Eskridge is going to talk for 10 minutes. He has the affirmative of the proposition that California's Proposition 8 violates the 14th Amendment. Professor Epstein's going to talk for 10 minutes. Then they each get 5 minutes to reply to each other. And then I may have a question or two, and the format will become more flexible. So I guess we'll start with Professor Eskridge.
Bob, did you want to lay out the background a little bit?
Oh, I did, and I promised you I would do that, and I forgot to do it.
Nobody knows it.
Even made notes on the subject. The story be the background that I think it is useful for you to have, although maybe you know it, but maybe like me you've forgotten the details. The history of this issue, I suppose the history can go back to Adam and Eve, but it was starting a little more recently.
Well, along with Adam and Steve.
I'll start in November 2000. When the voters of California passed a statutory initiative known as Proposition 22 to enact as a statute that marriage should be limited to opposite-sex couples. Obviously, that did not change the law of California, but it gave it, I guess, the imprimatur of a public vote. In February of 2004, the mayor of San Francisco started to issue marriage licenses to same-sex couples, and in the following month, in March of 2004, in the Lockyer case, the Supreme Court of California held he could not do that, but it so held without addressing the issue of whether Proposition 22 or the limitation of marriage to opposite-sex couples was constitutional. That issue did finally get decided in the marriage cases in May of 2008, in which the California Supreme Court held that the limitation of the institution of marriage to opposite-sex couples violated the California Constitution. As of that point, and I believe until this year, as far as I know, no court, I think, had addressed the very specific question that you have before you today. Does Proposition 8 violate the 14th Amendment? All the litigation I know about had been brought under state constitutions, not under the 14th Amendment to the United States Constitution. Except I think there's some artifacts in previous years, but certainly the significant cases had been in the state in the states. Proposition 8 was a response to the marriage cases. It was a referendum enacted in November 2000, or an initiative enacted in November 2008 to amend the California Constitution. So unlike the the earlier initiative. This was a constitutional initiative, and essentially overruled the marriage cases and said in a simple sentence that marriage in California shall be a relationship between a man and a woman. That was attacked on state constitutional grounds, on the theory that the proponents of the initiative had not followed the procedure required for amending the California Constitution. That was rejected in Strauss against Horton in May of 2009, and then the proponents of same-sex marriage went, I believe, for the first time to a federal court in the Perry v. Schwarzenegger case, which was decided just a few months ago by the district court. Chief Judge Walker held, he answered the question we have before us, and he answered it yes, that California's Proposition 8 violates the 14th Amendment. And now I can give Professor Eskridge 10 minutes to tell us why he was right.
Yeah, I'm actually going to depart from Judge Walker's opinion. It's 130-some pages. I'll give you much less and a much narrower ruling under the 14th Amendment. And my focus is really going to be, it's going to be the text of the 14th Amendment, the original meaning, and binding precedent, which I think it's always good to return to first principles to address precisely what Judge Smith has laid out to you. I've given you a handout. Everybody in hers or her sheet should have a handout with the relevant texts before you. The text of the Equal Protection Clause, which you probably already know, nor shall any state deny to any person the equal protection of the laws. That is a very broad text, authorizing perhaps a very large amount of judicial activism. And so most theories of the Equal Protection Clause have tried to narrow the text to something like a limited number of cases, leaving most statutes virtually impregnable. One way to think about what the limits might be or what the core might be is to look at the original meaning. There's a lot of scholarship on this. Melissa Saunders, my student, who clerked for Chief Justice Rehnquist, and Bill Nelson has written the main book, they're referenced there, have concluded, and dozens of other scholars support them, that the core purpose of the Equal Protection Clause was to strike down class legislation, as was understood in the 19th century. Senator Howard, who introduced this in the Senate, said this would abolish class legislation in the states and do away with the injustice of subjecting one caste of persons to a code not applicable to another. There are surprisingly few Supreme Court precedents really addressing this core purpose of the Equal Protection Clause. And certainly the leading recent one is Evans versus Romer and Evans, which involved, coincidentally, also one of these popular initiatives. We've reproduced the reasoning of Romer versus Evans right there, without applying strict scrutiny, but applying a scrutiny that was much less forgiving than traditional rational basis for a initiative-based law that took away a fundamental right from just one minority and was not closely supported by a neutral state interest. That is precisely what was involved in Romer and Evans. The Supreme Court struck that down. And ultimately, the basis is probably that the Supreme Court felt this was too close to the core of the 14th Amendment, was class legislation. Now let's look at Proposition 8 in light of these fundamental principles of law. Proposition 8, I don't need to repeat what Judge Smith said, but what I can show you are some of the relevant texts under the handout. So in the marriage cases, the precise holding of the marriage cases, just elaborated a slight bit on what Judge Smith said. The further holding of the marriage cases was not only that the exclusion of lesbian and gay couples from civil marriage, not religious marriage, but civil marriage, was a violation of the California versions of equal protection, but also that these violations were not cured by the existence of a separate institution, domestic partnerships, which the court treated as providing all of the legal rights and duties, including adoption, child rearing, etc., that the marital institution gave to different sex couples. So it's literally creating a separate institution, but with a different name. And the court held that the lesbian and gay couples were denied their fundamental civil rights by the exclusion, and it was not cured by this separate institution. Proposition 8 made a decision not to repeal the domestic partnership law, but only to override the court's decision that the institution of civil marriage should be available to lesbian and gay couples on the same terms available to straight couples. In the official ballot pamphlets and in the brief that I've filed, I give a lot of documentation to other things in the record and things not in the record. Here were the three arguments that were made by the supporters of Proposition 8 in the ballot materials and then subsequently. And they're at the bottom. The three purposes were the following. Number one, it restores the definition of marriage to discriminate against lesbian and gay couples. Number two, it overturns the decision of the 4 California Supreme Court justices who ignored the will of the people. This is the median voter model that Richard and I were talking about somewhat disparagingly yesterday. And then three, and this was the main one emphasized in their television commercials and such, it protects our children from being taught in public schools that same-sex marriage is the same as traditional marriage. And then, as you know, Proposition 8 passed by a majority of the people voting. A fairly narrow majority, but a decisive one nonetheless. Now, here is the argument that I would make. I think it is not wise for federal judges, and probably state judges as well, Judge Smith might appreciate this, to rule more broadly than is necessary. However you come out, if you come out in favor of Judge Walker, I would urge a much more narrow approach than the broad one taken in Judge Walker's opinion. My argument is that if you take the Equal Protection Clause's language seriously, the text, and the original meaning, the purpose, and the precedent that is binding on us, then this has unconstitutionality written all over it. And here's the kind of argument I would make. Number one, it is very interesting that, like the initiative in Romer and Evans, this is a novel initiative. It's not novel for initiatives to say we're going to reaffirm the existing bars to same-sex marriage, or we're going to constitutionalize it. That's not original, that's not novel. What is novel is that in a state where lesbian and gay couples had been recognized as having a fundamental right to marry, and it was embedded in the state constitution, that was taken away by a voter initiative only from those couples. It is novel. It is the deprivation of what the state courts had said was a fundamental right, and it was leaving these couples with what the state court, which is binding on the federal courts, if I'm not mistaken, said was a second-class institution of domestic partnership. Now, that's point number one. It's not the most important point, but it does show a great similarity to Romer and Evans. Here's point number two, that the demotion of this one small class of citizens was accomplished based upon open appeals to anti-gay animus and anti-gay morality. Generally speaking, when initiatives are upheld, it's because the initiative supporters can say, well, there's some kind of tangible John Stuart Millian harm that this discrimination is meant to cure, and there's a plausible reason to think that it will cure it. Well, it's a harder case to make here, Judge Smith, than it was in New York, where, remember, there was no domestic partnership institution, and in other states where it was not accomplished in this same way, and also because the record was filled with open appeals to anti-gay animus, and Judge Walker made a number of findings of fact. Traditionally in California, starting with the administration of Earl Warren, governor from 43 to 53, lesbian and gay citizens of California were demonized as anti-family, as predatory towards children, as second-class citizens, or indeed as criminals. That was the tradition which we had in California. The appeals in the Prop 8 materials were overwhelmingly, in the campaign, appeals that children would be brainwashed and recruited by homosexuals and lesbians, as they called them, because marriage was now afforded these citizens the same as it was afforded other citizens. Now, aside from tying into the traditional stereotype and prejudice-based appeals that other referenda, starting with Nita Bryant, had made, this argument was palpably false if you look at California law, and we've provided the texts of the relevant California statutory provisions before the marriage cases and after Prop 8. And before the marriage cases, California schools were and still are required in their health classes, if they talk about this stuff, that they are required to respect marriage and committed relationships. That includes domestic partnership. They are also prohibited, they engage in instruction, from discriminating on the basis of sexual orientation. None of that is changed by Prop 8. All of that was fully in place, whether or not lesbian and gay citizens got the dignity of marriage as well as these other things. And then finally, a parent with religious objections has an absolute statutory right to remove his or her child from instruction that conflicts with those beliefs. The open appeals in the Prop 8 campaign were based upon the denigration of one group to second-class status, and that language is the California court language. And then finally, and this also ties it into Romer and Evans, the court in Romer and Evans looked at the asserted state interests and found that the discrimination against lesbian and gay citizens was both over and under-inclusive to the interests that were asserted. It is interesting, on appeal, the appellants, the supporters of Prop 8, have abandoned the three arguments that were the basis of the ballot materials. They're scarcely even mentioned in the brief. What the brief says is the main argument is that the state's, I'm quoting them, vital interest in increasing the likelihood that children will be born and raised in stable family units by the couples who brought them into the world. I do not see any causal relationship between excluding same-sex couples and inducing straight couples to rear their children in stable family units. There are indeed many policies, such as tougher divorce laws, abolishing legal cohabitation, education campaigns. There are lots of policies that would contribute to the goal of inducing straight couples into marital relationships to raise their children. All of those policies would limit the liberty of straight people. Using gay people who have not contributed to the decline of marriage as scapegoats for marriage's decline and to repair the habits of straight people is not only an example of scapegoating, but I think is ultimately, in this case, a violation of the Equal Protection Clause. Just like Amendment 2, Proposition 8, and I'm quoting Romer and Evans, is at once too narrow and too broad. Appellants mention a few other interests, such as preventing the decline of marriage by discriminating against same-sex couples. We can talk about that in the Q&A, because that also shows up in other states, but it was not the main argument made in that brief.
Professor Epstein?
Thank you. This is obviously a very difficult topic to address, and particularly for somebody who thinks that the entire litigation is ill-conceived and is at the same time something of a fairly ardent libertarian on matters of personal behavior. So let me first sort of give what I think to be the sort of the political case with respect to gay marriage, which comes out, I think, very much in the direction that Bill would want it, and then to explain the question why is, I think, in the end, that the political case doesn't become a constitutional case, whether conceived broadly, as I think this debate was originally conceived of, or narrowly in connection with the particular circumstances of Prop 8 and the history that preceded it. The single most salutary position, in many ways, of a libertarian thinker is that the fact that you are deeply offended about the conduct of other people gives you no warrant to alter it, to change that contract, unless and until it involves the use of force and fraud against you. There are obviously antitrust kinds of issues, which we could put aside. I've never heard anyone say that a particular marriage was in restraint of trade. Bill may make that argument, but I won't. So what you do is you have yourself at this particular personal level, and when somebody comes through and starts to tell somebody else how he ought to live his or her life on the most intimate details of personality, what you really want to do is to call for some sort of a really powerful warrant. And it's very difficult to bring this within the Millian principle of harm to others if harm is defined in a way that excludes that kind of an offense. So for somebody like myself, itself. The difficulty is not with the institution of marriage, it's the institution of marriage licenses. And the real question you have to have is, if marriage is some kind of a natural associational freedom, why is it that the state can horn in and decide that this or that person can or cannot get some kind of a marriage license? And what happens is you can justify this on the grounds that people are too young, standard arguments of one sort or another, and all of those standard minority, i.e. in minority in age, protective kind of interests are obviously not what's at stake in this particular case. And so if you're going to move to a system of state marriage licenses, it seems to me that the doctrine of unconstitutional conditions is going to apply in some sense. And as the state ought to, if it's going to give you the licenses to one kind of people to engage in a transaction, has to have very strong reasons before they deny it to any other kind of group. And as a matter of straight political theory, I think that this thing would start to fail. And so you would come up with a world in which everybody would be profoundly indifferent to the fate of other people and the way in which they marry. And the great virtue would be this: if it turns out that your offense doesn't give you any particular claim over other people's moral virtues and so forth, since you're not getting out of anything by being perpetually agitated that there are gay couples about, what happens is your agitation starts to go down. And what we do is we get what I would like to see in this political economy, is a situation in which carelessness and indifference takes over on this particular issue, so that even if we don't live with mutual respect, we can live with mutual cordiality. And I would hope that that would be the way that this particular issue will go. And politically speaking, notwithstanding all of the ups and downs in this, I think that is the way it has largely gone in the United States. If this is only a debate over the question of whether or not you attach the label of marriage to civil unions which have all the rights and disabilities associated with other kinds of situations, this is not the 1968 debate as to whether or not we ought to remove gay and lesbian conduct from the list of criminal conduct as sanctified by the American Psychiatric Institute and so forth. So you should understand that we've gone very, very far, and it just turns out that it's the last 5% of this particular journey which seems to be causing all of the grief. How ought we then to think about this? And my own very deep preferred situation is that you wait 5 years, run another referendum, bring this thing 54-46 in the other direction, which I think would surely be the case, and we would not have the problem of constitutional argumentation to worry about. We would certainly have the argument of political legitimacy squarely on the side. So I'm not a real fan of this particular approach, just as a matter of trying to figure out how it is that you organize a polity. So then the question is, how do we think about this in terms of constitutional law, which is what Bill is talking about? And if you think about this, what I would want to say is that he gives us a very, shall we say, swift history of the Equal Protection Clause, which picks the highlights, all of which point in one direction, and ignores some of the really powerful features which rather cut in the opposite direction. So let me sort of explain the way in which I tend to think about the Equal Protection Clause. First of all, you look at where it comes in the Constitution. It comes at the end, and it comes after a Privileges and Immunities Clause and a Due Process Clause. And it's clear to me that if you're trying to figure out where it would be that substantive rights, like the right to marry somebody of the same or of a different sex, would be located in the Constitutions, it would be in Privileges and Immunities. And I think if you were to put the proposition up front at a time when homosexual conduct was often universally regarded as criminal, that this was now something which was given constitutional protection under the Privileges and Immunities Clause, or if you went back later to Pierce against the Society of Sisters, and when you're talking about the liberty interests under the Due Process Clause, that Justice McReynolds would have thought that the right to marry, which he refers to in that particular opinion, included the right of same-sex couples. If you ask the question today, one could creatively reimagine the way in which they thought about it, but historically nothing was further from their thoughts at any single point in time. So the question then is, if this is what the sort of reality on the ground is, how do we reconcile it with the doctrine in the form in which it existed? Well, the first thing I said is I noted that you would not have put it in Privileges and Immunities. What's left to the issue of equal protection if Privileges and Immunities is rightly dealt with? And I think here Bill is actually wrong. I don't think that the first purpose associated with the Equal Protection Clause was to deal with class or caste legislation. I think the first purpose of Equal Protection Clause Clause emphasized the word protection as much as it did emphasize the word equality. And what was going on is we had a system in which there was, shall we say, on an individual case-by-case basis, a perverted enforcement of the criminal law, such that if you were a black defendant, you would be subject to one set of harsh penalties, and if you were a white defendant, you would be subject to essentially a slap on the wrist and let go in congratulatory fashion. And I think conversely, there would be situations where if the victim was a black person, the prosecutor would be indifferent on count of race, whereas if it was a white person, he would go after anybody and everybody, and that it is a great and noble purpose of the Equal Protection Clause to try to make sure that differentials with respect to criminal enforcement are absolutely at the front and forefront of the overall situation. And once you see that, you now have a really powerful and good reason. It fits in very well with the political temper of the times. If you go back and watch what happened in the South after the protection from the North was withdrawn in cases like Crookshanks and so forth, you see the kind of differential criminal enforcement which indicated the wisdom of that decision. It doesn't implicate caste and class at all. So what happens is Slaughterhouse, of course, is a great disaster, the sort of the most disappointing opinion in the history of Western civilization in some sense, in which you abandon the substantive thing. Well, it then kind of resurfaces within years, literally, through the Equal Protection Clause and through the Due Process Clause. And then we hear all this talk about class and caste legislation. Well, I mean, just remember what this could possibly do. If, in fact, the only thing you start to think about are classes and caste, then, in effect, the number of statutes that become unconstitutional becomes exceedingly large. And now, of course, I assume that Bill is having noticed that class legislation involves those individuals who are in a class that can only earn $2 an hour when the minimum wage is $3 an hour may be well singled out. And the entire course of economic liberty could become class legislation, because that's exactly the way those cases were argued, both on the liberty grounds and on the equal protection grounds back in the period of substantive due process. I happen to think that that's probably a fairly noble endeavor, and if I could get Bill to come along with me, I would be quite happy to yield the ground on Proposition 8 if we could return to a really systematic and thoroughgoing explanation of how it is that class and caste simply annihilate 99% of the current social democratic welfare state. But, and there's always a but that comes with these particular situations, there was, in fact, in the 19th century, a well-documented, completely screwed-up attitude on some of these questions, which I think is important because it helps explain the psychology associated with the current time. Bill made no reference to the morals head of the police power. And for those of you who've done legal history on this country, there's this fearsome quartet. It's health and safety, which most people kind of understand. Then there's the general welfare, which starts to get a little bit squishy. And the last head of the police powers was the morals head of the police power. And what is so clear about the American Constitution is that it reflected the dominant attitudes of its time, that a people who would be relatively laissez-faire with respect to a variety of economic issues would become highly centralized, completely dogmatic with respect to the norms that develop with respect to sexuality, gambling, and other sorts of potentially sinful sorts of behavior. And there's no question that for a very long period of time, a history which is eventually reversed in Griswold in Connecticut, what happens is that anything that falls within the head of the morals head of the police power is essentially per se constitutional, no matter how irrational, no matter how crazy, no matter how foolish. And I have to say that as a matter of normative political theory, given what I've said before, this is not what I regard as the high point of American constitutional jurisprudence. But what you really have to then ask yourself is, why is it that this structure lasted as long as it did? And it turns out that what's really going on with a lot of the stuff associated with gay marriage is a very complicated duet between the rational normative approach which Bill takes. He lists all the interests which they show in favor of the particular attitude that you have on equal protection and says that the state justifications fail. And I'm going to tell you he's right on every one of them. I mean, you're not going to be able to make this thing out as a way of protecting children or anything of the particular sort. But the historical view, I think, represents a different view on psychology. There's a wonderful book whose name I always forget by a fellow whose name I happen to remember, a man named Jonathan Haidt. And what he said about moral judgments is that they're built in a hardwired sense. First you have the judgments, and then what you do is you form some kind of social rationalization before them. And it turns out that historically this seems to be quite accurate, because when it comes to matters of sexual behavior and reproduction and family and so forth, whatever the instincts we are given with are highly regimented and highly authoritarian. And so what you're constantly trying to do is to figure out a way in a civilized society to rein in your own worst impulses at the same time that you understand the rational arguments on the other side. Now, this is a very enlightened group, but the voters in Iowa may not have been so enlightened on some of this stuff. And what happened with respect to them is that those instincts are there. And even though you may be able to persuade them to go over, what they truly resent is that traditional values deeply held will be swept aside. I think Bill was absolutely right to disavow most of what Judge Walker said in that opinion, because the last thing you want to do when you have a population which is struggling with an issue on which it's making some degree of what I think is moral process is to say that everything you've ever believed from the beginning of time is so completely irrational. We don't have the slightest respect for you or for anyone who's done this. And we got Nancy Cott, who happens to teach at Brown University, and she will now tell us authoritatively that gender was never at the core of marriage. Of course, she's right. Gender wasn't at the core of marriage. Sex was. And what you do is you falsify a tradition, you falsify a history, and then people, and I will just end on this note, they wonder what's the agenda. My view is that you got a very strong libertarian case for freedom of association because the state's got a monopoly on marriage. But what happens is the rationales tend to go. So suppose we were now to start to say that, look, well, we're going to do the same thing with polygamy. There's no argument that you can make against polygamy which is any stronger here. And frankly, I would like to see those bans reversed. Frankly, I'm not running for public office, right? So the two things I think go well together under these circumstances. But you also sense if all of these distinctions are completely irrational, then in effect when you get to an anti-discrimination law, you're going to have exactly the same problem. There you are with this artificial, archaic institution known as the Catholic Church. They won't allow priests to marry. That's clearly unconstitutional. It's class legislation, right? They won't admit women into the priesthood. They seem to have survived fairly well. I happen to disagree with some of their policies. In case you know, I'm not a card-carrying Roman Catholic. But the Jewish boy from Brooklyn does not think he has it within him to tell the rest of the world how they ought to organize their associations. And the problem with the Walker approach is that it makes this so dependent upon his epistemic findings that you now wonder just where this is going to happen. Bill is aware of this. He doesn't do that. But he did something which in some sense I regard as worse. I thought we were going to debate whether gay marriage was okay under the 14th Amendment, and instead I now have the proposition which says if you once legalized it, then took it away by referendum, you have a federal right on the Constitution, so long as you have a right to withdraw your students from those classes which teach the way about gay marriage, which you really don't want to have. That's not the way you want it. You don't want to make an argument in favor of gay marriage which works under the peculiar and twisted history of California, which ought to be a leader for nobody in any area. You want what you want to be able to say is straight up, do you think that this is a classification which ought not to be tolerated? And so my view about it is half measures are a sign of intellectual weakness in this case. I'd actually respect the argument more if it went the other way and said, we don't care about this tangled history. For all people at all times, this is the way we want to go. But there's a real conflict here, and I'll end on this note very simply, is that how much of constitutional law is rationality, how much of the constitutional law is tradition and psychology? If you push yourself too far on the rationality stuff, the world is going to push back upon you. We're all imperfect human beings. You could make an immense advance in this particular area, but the only way in which you're going to be able to do it is to pull the reins back a little bit and let the horse go at a slower pace, not to throw a whip upon it, at which point you may take the entire carriage and collapse it. Thank you.
Okay, just to show you that I'm keeping track, Professor Eskridge, he spoke for 3 minutes more than you did, so he owes you 3 minutes. So why don't you take something in the range of 5 to 8 minutes to reply?
Very good. Can you hear? Okay, the sound system is down.
Just retribution.
My
talk about silencing. First of all, the PowerPoint, now the sound system. Okay, there's much agreement. Let me start with points of agreement. And Richard, I have one friendly bit of advice for you.
Uh-oh.
No, this is good advice.
Wait a second, let me get the
This is
wallet
not the homosexual agenda. This is good advice for the young man. And the good advice is, let's keep an eye on the ball. Our main thing is the flat tax. We do not want to discredit your flat tax agenda by associating it with polygamy. Okay?
Fabulous
Can we all
advice.
agree
I'll
with that?
remember that.
Okay. So that's a mild disagreement. I think Richard and I are on the same page on that one as well. Now, here's another place where we're on the same page. I've said this in print repeatedly. A week after the Olson and Boys lawsuit was filed, Ted Olson, excellent attorney, very thoughtful, and I think dead wrong to have filed this lawsuit, which I've said in print repeatedly. I think exactly the way Richard thinks on this. I think the right way to go has always been to go back to the people in 2012 and win the initiative. And I've been saying that in California for the last 2 years during the Olson and Boys lawsuit. And hopefully there will be an initiative in 2012, and hopefully that initiative will come before this lawsuit is finally resolved. One of the things we didn't talk about is that it might be resolved ultimately on standing grounds. We could have had a debate on that. So we're actually in agreement on that. And I'm also advocated 10 years ago in a book called Equality Practice that the way to proceed on these divisive issues like same-sex marriage is through a political dialogue, most of which is carried on at the legislative level and should be carried on at the legislative level. Vermont was the premier state, and I was building on the Vermont experience in a way that has proven prescient, because we now see legislatures signing on, including California, where the legislature twice passed same-sex marriage bills that were vetoed by the governor. So I still think this is the way. I think the role of courts necessarily has got to be a modest one, and this is why I would not go as far at this point as Judge Walker does. And I do respectfully disagree with Richard that if the question is, does Prop 8 violate the Equal Protection Clause of the 14th Amendment, why or why not? I think a narrower ground is much better at this point than a broader ground. And I think the broader discussion, with all due respect to Richard, should be at the legislative level and in these initiatives. Now, here's the political theory reason, and it's a Yale reason. Robert Dahl, the great political theorist at Yale, said that issues that intensely but evenly divide the polity are genuine threats to democracy. In other words, issues that are identity-based on either side. The gay marriage issue, it seems to me, is a classic example of this, where on the one side, supporters of gay marriage, it really implicates our relationships, the relationships of our family members, and so on and so forth. It's very personal. It's very identity-forming, and that includes a lot of the allies as well. On the other side, I would say the same thing, however. For many people, the limitation of marriage to one man and one woman is a matter of their religious identity, or maybe more broadly even than religious. And that is a classic example. It's like the abortion debate. It's maybe like the slavery debate was back in the 19th century. And one of the things, just as a thoughtful matter, that I would urge upon you is that both President Bush and Ted Olson were wrong. And actually, I think you'll agree with me. I doubt there are many people here who've ever uttered the same sentence. Yes, Ted Olson and George W. Bush are both wrong on the same issue. But it's a fact. Ted Olson is wrong in trying to bring premature closure on this issue through a Supreme Court decision that imposes same-sex marriage everywhere. And George W. Bush, with respect, is wrong in supporting the Federal Marriage Amendment, which sought to amend the Constitution to produce closure on an issue where the nation was not yet at rest, and today is not yet at rest. So I think it needs to go state by state. And that's why I make my case very much specific to the state of California and to the initiative process. And I don't need to repeat the dozens of criticisms that Tom Merrill and Richard Epstein and I announced for the initiative process in yesterday's panel. Now let me talk, if I could, about the few areas of disagreement actually between Richard and me. And I think there's one legal disagreement, and then there is a broader disagreement about morality and so on. The legal disagreement is that I think Richard is wrong in saying that class legislation was not the fundamental thing that the framers, I'm not talking about Chicago School 100 years later, I'm talking about the framers who wrote the text. As Justice Scalia has nicely reminded us, equal protection of the laws was understood by them to mean the protection of equal laws. Where does this class legislation stuff come from? Read the history. It is brilliantly assembled in Chief Justice Rehnquist Clerk's article, Melissa Saunders, in the Michigan Law Review, 96 Michigan 245. And what she does, she traces the anti-class legislation idea back to the late 18th and early 19th centuries as interpretations of the Due Process Clause at both the state and sometimes even the national level. And exactly as Richard points out, it was very often economic class legislation, but it was sometimes other kinds of class legislation as well. That idea was then available to the framers, the drafters of the 14th Amendment, and according to Melissa Saunders' article and Bill Nelson's still classic book about the history of the 14th Amendment, that was the animating idea. I've given Senator Howard, I could have given dozens of quotations from their articles and from that book. And then Bill Nelson, and to some extent Melissa Saunders, then document that at the ratification debates, this was the main selling point for the Equal Protection Clause in particular. Okay? So what do I mean by class legislation? According to the historical materials, which we should attend to, class legislation is bundles of prohibitions and limitations that set forth one class of citizens as separate and as degraded and inferior. And one way to see, I think the superior way of seeing the Equal Protection Clause's history, mainly in the race cases, and now the sexual orientation cases, is that the Equal Protection Clause was an instrument. It was not the main instrument. Legislation is always the main instrument, Civil Rights Act 64. But it's an important instrument in whittling away clusters of caste legislation. And in California, exactly as Richard says, starting in the 1940s, lesbian and gay people were established as a separate caste because of assertions that they were predatory toward children, they were anti-family, they were harmful to the citizenry. And then for the last 30 years, there's been a chipping away of that, mainly by governors, administrators, sometimes judges, sometimes by the legislature. And that's what I mean by caste legislation. Now, one final disagreement is morals legislation. There might not be any citable Supreme Court opinion that upholds a statute based only on the pure morality justification, that this statute is supported. Now, Bowers and Hardwick might be an example, but it has been overruled. This policy is accepted as moral by a majority of the citizens, and that is the reason we uphold it. Generally speaking, the Millian justifications dominate the Supreme Court opinions, even under the rational basis approach. And the caution that I would utter here about an expansive understanding of morality-based justifications, which were renounced in Laurence, and there are other cases that could be cited, is there's a very thin line between pure morality and prejudice and stereotypes. One person's prejudice is another person's morality. And that, unfortunately, ties back into the Dahl thesis, that this is not something that judges are perhaps best equipped to handle or even to understand, okay? And we've certainly seen that in the lesbian and gay cases. I will say this, and that is to the extent that you have a kind of rational basis approach with any teeth, which is the holding of Evans and Romer. A good place to show that teeth is for statutes that reveal anti-gay animus. It has three disabilities which are in the public interest to push back against. One is that the operation of anti-gay animus is inefficient. It's not just irrational, it creates inefficiencies. This is recognized by most business people in the world and many in the United States. It certainly is unfair to lesbian and gay people. And it's particularly unfair, as the defense of marriage argument usually posits. President Clinton, remember, he was the big defender of marriage. Speaker Gingrich, another defender of marriage. The nation's two most prominent adulterers defended marriage for you in the Defense of Marriage Act. based upon the proposition that marriage was under siege, it was in decline, and the Maginot Line for defending marriage against straight people's straying was to deny the institution to committed lesbian couples who are raising children within that relationship. Now that, aside from being a morally squalid position for either President Clinton or Speaker Gingrich to take, is also profoundly unproductive if you want to do something about children who are victims of broken marriages, spouses who are pauperized by no-fault divorce, et cetera, okay? And then thirdly, from a pluralism point of view, 30 years ago, I'm sure many of you can remember, lesbian and gay people were certainly not an important group in American society. They were an outlaw group. That is no longer true today. And the difficult project, which I completely agree is a political project overwhelmingly, is to integrate that minority group, which is a group of worthy individuals, many of them in committed relationships, within those relationships raising children, to integrate that group into American society as a legal matter with the same dignity and legal respect that traditional groups have had. But on the other hand, without roiling the body politic the way we've seen with many of these other identity-based issues, such as slavery, abortion, and so on and so forth.
I mean, I'm very glad to agree that we agree both on the flat tax and on the need for political innovation in order to handle the issue of transformation with respect to gay marriage. And again, I do want to reflect that the enormous transformation from the time that I was a kid growing up in the 50s and 60s, where all these behaviors were regarded as simply beyond the pale, to a situation where the debate is only on the question as to whether or not a name or a symbol should attach, when all the underlying legal incidents associated with putting couples together have been pretty much broadly approved. I do think that this is an enormous level of progress. The question that we want to ask, however, was, as I thought, a constitutional question at one level, and so let me comment at a couple of things. One is, I think that Bill is wrong in thinking that somehow or other the way in which you manage and understand the social significance of a decision is to figure out whether or not the rationale for it is broad or whether it is narrow. In the case of something like gay marriage, if you invalidate Prop 8, even if there was nothing else in the sun that would be invalidated, it is essentially a cosmic blow with respect to the way in which the political institutions organize themselves. And there is nobody who is either for it or against it who will think that it is qualified by the peculiars that we're talking about in this case. It also suggests that if you're doing this under the federal Constitution, you're going to have to run a similar case-by-case analysis of the state of affairs in any other state where the particular challenges are going to be made, where this is not a binding precedent, but is only a possibly persuasive one, if that at all. And if you really want to create real political difficulties, just have a muddy ruling which leads to lots of individual disputes which will turn out to be inconsistent with one another. I don't think that's the way one wants to understand it. I think one has to sort of bite the bullet and to say, we don't care about rationales in this case. What we really understand is you either can or you cannot do it. And once you make this decision, it may affect only one institution, but it's an institution that lies at the heart of the way in which many people conceive themselves and their nation. So then the question is, how do we go back to all of this stuff and deal with class legislation? Let me sort of just elaborate a little bit on what I meant by the way in which I talked about it. I don't think that anything Bill said either could defend or did defend the proposition that differential enforcement by the executive branch somehow or other would be immune from the supervision of the Equal Protection Clause so long as you did it under a general statute of murder and so forth. What you clearly have to do is to say to yourself, suppose the legislature now sees that there are these kinds of patterns that are illegal when done by individual prosecutors, and what it tries to do is to essentially legalize the situation by passing a statute which says that the crime for rape when committed by a black man shall be 20 years, when committed by a white man shall be of 6 years, or something of the sort. We would never tolerate the institutionalization through legislation of a set of practices that we would not allow to take place as a matter of executive order. So that what happens is that the Equal Protection Clause is going to grow in order to deal with the legislative responses to executive practices. And this is a perfectly sensible way to think about things. A constitution is always a cat and mouse game. The cat turns out in some particular case to be the Constitution, and the mouse are the political branches. A mouse does something sneaky to escape from the cat, and the cat has to basically set the web a little bit wider so as to bring things in there. The whole problem of how it is that you deal with public officials who are willing to circumvent constitutional duties, it would drive you to that particular dimension. But even if you give all of that, there is not a word which is said about how this tied into the moral stuff and whether or not there were certain kinds of divisions that were regarded as permissible at the time for which you would not have to go through any of these situations. So if you wanted to figure out how selective prosecution worked in 1866, if you have uniform prosecution of all homosexuals regardless of race or sex, you would be just fine under the Equal Protection Clause because the basic category of illegality had been well established under the laws of its time. And that's the sort of moral and political battle that we're trying to face. Can we say this is a matter of constitutional history? Well, remember, you can't do that if what you come up in a discussion and says, well, that's the way it was, at which point, of course, everything they did in California now becomes in some sense legal because of the constitutional blessing it gets from the morals head of the police power, and it all changed in 1986. Well, not in 1986, because Bowers and Hardwick said that was basically okay. I mean, if you're trying to talk about the way in which the American Constitution and the Equal Protection Clause works, you cannot take Laurence v. Texas as the sole benchmark of this. You have to recognize that it's a U-turn from the earlier cases. And then how does that work? Well, I mean, my view in many ways is that Laurence v. Texas was an exercise in what I would like to call prudent cowardice. And the reason that it was prudent is I think Justice Kennedy realized that if he were to have a statute which announced that gay marriage was protected when he was dealing with a sodomy prosecution between a same-sex couple under a peculiar kind of Texas law, he would have had a palace revolution on his hands. So what he did is he made one of those indefensible constitutional distinctions in which he said that class distinctions that are relevant with respect to criminal prosecution don't seem to apply with respect to the areas of marriage. And gay marriage was essentially kept off the table. And this was the usual situation that often happens with judges, is they don't like the power of the unconstitutional conditions argument to basically translate everything that applies to the use of state force by way of punishment to talk about the use of state benefits when it starts to have selective distribution. And it started out as a left-wing movement. I'm happy to say I believe it's a universal movement. The whole notion that the right-privilege distinction is one of sort of great constitutional distinction is perhaps the only myth, I think, that should be fully exploded in terms of American constitutional law. We saw the adverse consequences of ignoring it in the Christian legal case that came down this year, where Justice Ginsburg said, well, if the state's just giving a series of benefits out, it doesn't matter whom it gives it to. Cross-subsidies are the nature of America. You really don't want to believe that because it's going to make this more difficult. So what's the bottom line that we have on this? I think the answer is that the weight of history is really very strong on this case. The weight of popular sentiment matters. If, in fact, we believe that the situation on the ground is such that the Equal Protection Clause doesn't work, we don't have a history which makes it inexorable in its application. What we do is we have a series of prudential political decisions that say, look, Loving v. Virginia is a rather different case from the situation with Perry against Schwarzenegger. In the one case when the decision came, there were no judges that were recalled. There was just a national celebration of relief. In this particular case, rather different. Respect the political situation. Understand that anything you do with the Equal Protection Clause is wrenched from its original context, and you don't want to be bravely innovative with a relatively staid text if it turns out that you're going to go into a political maelstrom. So just basically take it easy and see if we could talk this thing through. My guess, give it 5 years. The demographics are inexorable on this thing, and I think and I will say it again, the weakness of the moral arguments for the legal prohibition are so strong that I think my view is I want those guys out there talking all the time because I basically regard themselves as self-refuting.
Okay, I'll before I open the floor to questions, maybe I'll try a few. I guess what struck me about the discussion, first, of course, the rather large measure of agreement on that as to maybe not how the lawsuit should come out, but how the the social debate should come out. I suspect there might be some in this room who disagree, but we have on this panel none who do. Let me ask, starting with one thing. The other thing that struck me about the whole discussion is neither one of you seems to want to do what I thought was the old-fashioned way to do constitutional law. You take a regulation, you say, are we going to give it strict scrutiny, or is it going to be a rational basis exercise? And we compare the law to the Constitution, we see how it comes out. Professor Eskridge, am I right in saying that you've got a new way of doing it that doesn't conform to that tradition? And the related question is, how does it come out if you do it the old-fashioned way?
Which one? Who's that to?
Oh, him first.
Oh, that's fine. Let him go face it.
Okay. Poor Judge Smith, the reason for your confusion on Richard and me is we bonded so much in yesterday's panel where it just carried over till today. It's the homosexual agenda to seduce the heterosexual, according to a lot of these myths.
Could you keep this clean, please? Yeah.
Absolutely.
That one didn't
But I think Richard and I are really a delightful same-sex couple. The only dispute is who talks faster, and I do believe it is
no,
Richard.
Yeah, I'm sorry, but you're. I'm afraid there's one aspect of the debate you're going to lose.
Okay, I take that. Okay, so the Judge Walker's opinion was what Judge Smith you're talking about is the more traditional inquiry. He asked it with there was strict scrutiny, and he found two different avenues of strict scrutiny. The primary one, which was the main holding, I guess, was that he found a fundamental right to marry, Loving versus Virginia, for different race couples. And I will take some issue with what was just said. I grew up in the South. Loving versus Virginia was not accepted by the South or the United States with open arms. Large majorities of Americans did not agree with Loving versus Virginia when it was handed down. So we don't want to rewrite history in that particular respect. And indeed, the numbers, I think, then against different race marriage were higher than the numbers today against same-sex marriage. But Loving versus Virginia is a site, Zablocki versus Red Hale, where Wisconsin had a statute which said that deadbeat dads, spouses who were in arrears in their support and alimony payments, could not remarry. Now, most of us think if you want to have a nosy regulatory policy, this is one of the better regulatory policies you can have. Supreme Court struck that down because it denied deadbeat dads a fundamental right to marry, and therefore they applied strict scrutiny or something like that. And then the final case that I know about anyway is Turner and Safely. I believe it's a 1987 case where Missouri said that convicted criminals, murderers and rapists, etc., who were serving time in prison, could not, while they were in prison, marry somebody. Now, these were people who, even if they could have gotten married, would not enjoy connubial visits. That was stipulated in that case. Supreme Court unanimously, albeit with Justice Scalia not voting, I don't know exactly what happened to him, whether he had a stroke or what, but for that one day he was out of the court. But otherwise it was unanimous in a case that was divided on the right to open mail. Justice O'Connor wrote an opinion saying the fundamental right to marry applies to convicted criminals. Okay? So if you take those lines of cases seriously, and they are the leading Supreme Court cases on the fundamental right to marry, there is, it seems to me, a prima facie application also to same-sex couples. Now, it's no answer to say, well, same-sex couples have not generally been allowed to marry in America. It's false, by the way, to say they've never been allowed to marry in America. They have. There have been legal same-sex marriages in America in our history. But traditionally, they have not been. Well, that's no answer. Virginia had never allowed interracial marriages. If you have a fundamental right to marry, the inquiry then becomes, does the state have a good reason not to let you marry? And for most of the state's prohibitions, there are some fairly obvious reasons. Maturity for underage marriages. I think there are some excellent reasons against polygamy that the state can advance. I'm sorry, Richard. We're not going to allow a third person in this relationship, even if it's Dick Posner. Okay? It seems to me that if you take the cases seriously, and remember Judge Walker is...
I'm having trouble taking you seriously.
Maybe. Judge Easterbrook has reminded us on many occasions that federal judges are inferior court judges, under the Constitution, and you all have got to take the Supreme Court precedents seriously. And under those precedents, there is a right to marry. Now that's if you take the law seriously and you apply it to these cases, and that was his main ground for strict scrutiny. He also flirted with, but I don't believe was wedded to, the idea that sexual orientation is a suspect classification under the Supreme Court's general criteria, and that would be another basis. I think his primary holding was the right to marry. You asked me my personal view. I said this almost 20 years ago in a book, The Case for Same-Sex Marriage. If you take the cases seriously, then there is, lesbian and gay couples do have a right to marry, but the state has to have a heightened justification to deny. If you take the policy of marriage in this country seriously, the policy of marriage in this country, just as St. Augustine told us in De Conjugale, that the primary civil purpose of marriage has been unitive. That's also one of the religious purposes. Marriage in this country, to my knowledge, has never been tied legally to fertility, the ability, the willingness, or the desire to actually have and raise children. And if you look at civil marriage in that way, if you have a lesbian couple, for example, including ones that actually want to have children and want to raise them within the relationship, but that want to express a commitment to one another, as well as take on the many disabilities that marriage imposes on you. It imposes lots of regulations, including fidelity regulations. If that couple wants in a public way to join that civil institution, it seems to me the state has to have a better justification for that than saying that we think that you're a morally inferior relationship.
Rich, try to make
I'll
a
be shorter
short reply.
I'll be shorter
These
than-
people have a few questions
Yeah,
too.
I'm sure they do, and I'd like to hear them. Look, on the first question about the standard of review in American constitutional law, I didn't talk much about it because in this particular case, what happened is that the current economic poverty of the classification game has become clear, because what Judge Walker says, I'm giving it the lowest possible level of scrutiny and still finding that it flunks, so why does he have to worry about whether or not it meets strict scrutiny or intermediate scrutiny? My own view about this stuff is I've always been a determined opponent of the rational basis schedule. I think, in effect, what happens is it tends to pander to the worst forms of redistribution through legislative intrigue, and I'm much closer to some cross between intermediate scrutiny and strict scrutiny, depending upon the nature of the statutes involved. So in this case, I didn't talk about it because there was just really nothing much to be said about it. This was completely disingenuous on his particular part. He was determined to strike it down. He didn't want to fight the precedents on the issue. So you give me a lower standard of review, I'll just find the statute more arbitrary than I would ever find anything before. As terms of the historical stuff with respect to it, there is no question that the view was that the traditional definition of marriage generated a fundamental right, which required some strict scrutiny to override it. But I think it's wrong to say, at least in terms of the precedents, that when those cases were decided, anybody had the slightest bit of doubt as to whether or not that particular definition of marriage was or was not accurate. They all accepted that particular definition, and so the question is whether or not strict scrutiny ought to apply to the definitions is not the same as it is to the justifications for its limitation. As to loving, I mean, yes, there certainly was in the South lots of opposition, and we do remember that it was a clear and unambiguous holding in Plessy v. Ferguson that anti-miscegenation laws were fully within the scope of the police power. But by the time you get to loving, there are probably, I don't know how many states, 40 or so, which had already gotten rid of the anti-miscegenation situations. And so you were on the back end of a political situation to which there was opposition, but you were not at the front end with the way you are with respect to gay marriages, which essentially has become contested at this point in virtually every state in which the thing has been done. And so the political context and the aftermath were there. People were upset about lobbying. I'm sure they were. Within a week, they were on to something else. The fact that we're still talking about this case and will for years suggests that the political dynamic is really very, very different. And so what I want to say again is that when it comes to the question of how it is I would like these things to be done, I agree with what Bill has said, and those are the arguments that I would make in the political forum. I think, in effect, they've already gotten 90% of the way there, and with a little bit more talk, we can do it. But I do want to mention one other thing, which I think is key and important, is that we want to do this for people who want to do it. We don't want to essentially say that religious organizations have to accept these particular definitions if for one reason or another they choose not to. The autonomy interests are absolutely critical in this case, and I think a lot of the objection to gay marriage comes from the fact that people perceive this as the first step in a much larger campaign of anti-discrimination laws and takeovers of various other sorts. And strangely enough, I think the opposition would be much weaker, and I hope Bill would agree with this, that an anti-discrimination law which says that you have to hire gay employees if you don't want to would be an unwise thing, even though you may think that the practices that ought to be involved should encourage those kinds of employment relationships. Okay?
Yeah, let me actually just agree with what Richard just said.
Good.
I do agree with that.
We got enough agreement already. So, yeah. We have a little time for questions. I'm told there's a handheld microphone somewhere in this room, and if I call on you, you're going to have to wait until it gets there. Yes, sir. Okay, they will bring you a microphone. Be patient.
My name is Briard. I'd like to give a point of view from a European perspective. I'm the chair of the French chapter of the Federalist Society. And as you know, in Europe, we have to face exactly the same issue under equal treatment. I want to say two things. The first is that the issue is no longer an issue for the countries of the Council of Europe. As you know, in Mayflower versus Austria in June, the Court of Strasbourg, which gave those 47 countries, ruled that same-sex marriage is not a question because it is not protected under the convention, just because provisions of Article 12 do not mention same-sex marriage. So the court said that it is related to every state, and in a way, we joined the position that Professor Eskridge mentioned, that it belongs to every state to decide. But we will not have on that issue one solution for the 47 countries of the Council of Europe. The second remark, and it is a question, is about equal treatment. In our country, in France, we do consider that it is possible to deny someone equal treatment when she or he is in a different situation. That's the constitutional tradition. That's the first reason. The second reason is not about religious reasons, not about morality. And we see that through a very secularist view. We do consider that it may exist a common good, a common purpose to deny someone equal treatment. And my question is there in the American constitutional debate any place for the difference of situation or the common good? Thank you.
You want to comment?
Sure. I mean, that's as old as Aristotle. That Aristotle's understanding of equal treatment was that you treat similar things similarly and dissimilar things dissimilarly. I really appreciate your comments from the European sector. And here's where the debate in the United States is, and I do follow it in Europe, and I think the debate in Europe is also along these lines as well, as it goes country by country, as I think it should. And that is the lesbian couple raising children in a committed relationship that wants to be married, are they similarly situated to Bill and Hillary Clinton, who are a different sex couple, perhaps an adulterous couple, raising a child very successfully, okay? So are they similar enough? Well, they're certainly dissimilar, not only in the fidelity to the relationship, the lesbian couple has an edge. They're dissimilar in the sense that they are a woman and a woman rather than a woman and a man. And as a woman, they could not have created their children inter se, though the doctors do tell me that you can create a child who's the genetic hybrid of the two women under today's technology. But I don't know that that's ever been done or ever even will be done. So that's the main difference. The question then becomes, what is marriage for? And at least from the civil marriage point of view, there are hundreds of benefits at the state level and obligations. There are more at the federal level. But at the state level, the benefits and obligations of marriage are overwhelmingly about the committed relationship between the two partners. The ones that have to do with children, not a single one of them either assumes or insists that children within the relationship have to be the biological hybrid of the two parents. So it's a genuine debate, but that's where I am. I would say the similarities dominate. Many persons of faith and others in the United States would say that the dissimilarities dominate.
Yeah.
And you
Yeah, I have just one comment, because I agree that there are complications here, but I think that even though the protections, a couple of comments, about the way in which this thing's done are not necessarily directed towards children, it's very clear that the traditional design of marriage was worried much more about the propagation of the species over time, which was of great importance, and the natural modes of production are the most efficient ways of achieving that, and that's why it was that this became the preferred system. It is said, and I think quite rightly said, that we certainly extend the privilege of marriage to infertile couples and so forth, but there's no particular harm in doing that given your purpose, because whether they're married or not married in gay or straight relationships, they won't have children. I think the fear historically was the opportunity cost of gay relationships relative to straight relationships, in the sense that if you had a gay couple that paired off, they would not have children, and so that you would lose the potential of keeping the population base somewhat larger. Historically, these issues are you big enough to survive, were much more, I think, salient to cultures which had seen themselves overwhelmed from external stuff, and so they kind of thought of this as a much more important objective than perhaps we do today, and that probably explains the difference in these things. The second point I want to make is I think Bill is wrong to do this. You're talking about generic classes. Surely to say that, well, we don't have to worry about this because Bill Clinton or whatever it is, Newt Gingrich, have engaged in adultery, this is not an argument one way or another about what kinds of marriages we want. It's just saying that when people engage in behavior which is inconsistent with their vows when they're allowed to take them, we think less of them even if we don't punish them. And certainly nobody would want to say that, gee, you know, it's a really strong argument against gay marriage if you start looking at the relationships that you see homosexual couples having higher rates of adultery than lesbian couples, so we permit it for one group and deny it for the others, or we look at the relative divorce rates compared to other kinds of marriages and draw some inferences on that. Now, I think you really want to decide the question of validity straight up or down and put all of those things to one side.
yeah, one sentence, Bill.
According to the 2000 census data, and preliminarily confirmed in 2010, between 1/5 and 1/4 of lesbian and gay couples are raising children within that relationship.
Okay, yes, sir. Wait a minute for the microphone to get to you.
I'm sure that's true.
I thought the title of the debate was, does Proposition 8 violate the Equal Protection Clause? I've heard a lot of discussion, including in the answer to the last question from our colleague from France, related to the question of, is it best for American society, considering what legislatures usually consider, for homosexual or lesbian marriages to be allowed. The problem with the constitutionality, I thought, went on the question of what is appropriate for the courts to decide and what is appropriate for the legislature to decide. I heard Professor Eskridge, I thought I heard him say, as far as polygamy is concerned, there may be good reasons not to allow polygamy. But if you're going to say that it is a constitutional question, how can you differentiate between protecting the class of homosexuals and gay people and yet not protecting polygamists, not protecting family members who wish to marry, the father who wishes to marry the daughter, or other unusual and unacceptable marriage partners. Isn't it, in the end, the question of whether courts are going to decide it, or whether we should leave it to the legislature to reach the conclusion that was the one area where the two of you seem to have agreed, well, in the end, it'll be allowed because it'll end an issue in society. And I'd like to hear how you can, just a final point, I'd like to hear how you can distinguish the courts allowing, overruling the state legislature's decision that it is not moral or best for society to have homosexual marriages, but to sustain the legislature's view against polygamous marriages.
Okay. So,
who
want you want
either both of us,
yeah,
or Richard can defend it.
you're big on polygamy. You answer.
I'm a big polygamist, yes. One half of the marriage relationship might be, but the other half surely is not. But we put that, the personal story aside. Look, I think there are actually serious differences between the cases. If you go back and you read Reynolds against the United States at a time when the polygamy statutes were essentially used with respect to the Mormons, you were talking about an explicit constitutional guarantee of the free exercise of religion. And this was surely a set of religious beliefs. And exercise covers conduct as well as it covers various kinds of prayers and rituals. And the decision kind of conceded that it fell within the prima facie scope of the free exercise clause, and then gave forward a set of justifications which said that this was not to be allowed. And those are the ones that varied between pathetic and impossible, because they were simply assertions of public morality disagreeing with this, and majority will being able to take over. An explicit constitutional guarantee as opposed to a parity guarantee, which was very, very different in terms of its origins. And it was also done, I think, for terrible reasons, including securing the forfeiture of property of those people who were found guilty of some of these kinds of offenses. And if you look at what's going on, unlike the homosexual or this marriage and so forth, these are intersexual marriage relationships. It's men and women all the way up and down. And you know, so for that, if you're trying to figure it out, you've got to go to an exploitation theory. Nobody tried to make out that case. And I think that all of those things would fail. The problem with the gay marriage is that it simply does not have that kind of text-specific support. So to give you the clear answer, I think the correct answer under our Constitution is that polygamous marriages should be protected under the Free Exercise Clause, and I think that gay marriages are not protected under the Equal Protection Clause. I think that's about as clear as you can get, and I actually happen to think it has the advantage of being right.
You'll endorse that view?
I believe that Professor Epstein has inverted the Constitution in a very literal way. I've already presented my arguments,
Literal?
sir. Excuse me. I've already presented my arguments, sir. The legal arguments are set forth in detail on the handout for why I think the California Prop 8, we were not asked gay marriage in New York. We were not asked civil unions in New Jersey. We were asked about Prop 8. And I do believe that there are excellent legal arguments why Prop 8, adopted by an initiative with a certain history, makes that unconstitutional.
Well, what about Richard's point, though, that it isn't really realistic to say that you can have the Perry case go one way and not apply to gay marriage in
I've
any
already
other
agreed
state?
with Richard on that. I was opposed to bringing this lawsuit,
No, he's saying-
partly for that reason. This is it's kind of a Sophie's Choice situation for us as the thoughtful nation. Because either way you go, although actually, you know what this does? It makes the standing ground very attractive for some appellate judge to go off on, and to say that the defenders of Prop 8, remember Governor Schwarzenegger and the Attorney General, refused to appeal. The only appellants are the intervening defenders of Prop 8, and if you have problems with taxpayer standing, just taxpayers can object to their money being spent for religious purposes, but they are undifferentiated from other taxpayers. You might have a problem with the Prop 8 defenders having standing to pursue this case through the federal courts. That ground for decision, which we were not asked to address, But Richard and I are notorious to straying off topic, would in this reason be a very desirable way for either the Ninth Circuit or the U.S. Supreme Court. And my understanding is the first hour of oral argument coming up in the Prop 8 case is going to be devoted, I believe, exclusively to the standing issue. Now, let me answer.
May I say something? Thank you.
I still haven't answered the gentleman's other question, which is what about polygamy, and why I do think that Richard is an example of inverting the Constitution. Polygamy, if it were litigated today, the state's defense would look nothing like what I have outlined the defense of Prop 8. The defense would not be, we don't want our school children to learn that polygamous unions are the same as non-polygamous unions. Instead, the defense would probably be a feminist one. There is historical evidence, there is current evidence. The state has prosecuted many of these polygamists. There is a lot of evidence that the polygamous institution, the institution of polygamy, which in our culture usually means one man and more than one wife, it's not just a bad deal for the wives and for the children. There are lots of examples of and by the way, John Stuart Mill, now that we're talking about him, John Stuart Mill, felt that polygamy was a very bad idea. And you can introduce John Stuart Millian reasons today, backed up with a lot of history, a lot of specific examples of abuse to children and to spouses.
Okay, we're gonna have to.
No,
We're going to have to give back the room, and I'm going to let Professor Epstein have the last sentence. You can have a compound sentence.
I mean, you certainly you certainly can find all sorts of arguments about abuses in relationships, but it's going to be much tougher to say that you could show cases of abuses which lead to a per se ban on these particular situations, when many of the abuses take place probably because the relationships are often done in secret and would not have that same problem if done legally. The second thing I want to say, and I don't want to stray off topic, is if there's a bad body of Supreme Court law, the standing body is essentially it. I mean, the judicial power shall extend to all cases in law and equity means that, in effect, when somebody wants to enjoin a public official that this is not to be done, this has never been applied at the state and the local level, and there's absolutely no authority whatsoever to believe that Justice Scalia is remotely correct in thinking that Frothingham versus Melling was correct. And this is exactly the reason we don't want that. You've got a fundamental judicial challenge. Somebody's raising one of these issues on constitutional law. I may think that it ought to come out one way. Somebody may think it ought to come out another. But it seems to me that if it is a constitutional issue, you want it to be decided on the merits. And unless there's a better plaintiff in a case that's coming up right now, I don't think you want to sort of duck these issues on those sorts of grounds.
I think it's obvious. I think this is one of the cases where it's literally true. We could easily stay here till dinner time, but we're not allowed to. So please join me in thanking him.
Thank you. Thanks to the moderator as well.
Take care, Bill.